You think that the more information you provide to the defense attorney during the course of being questioned at a pretrial deposition is going to help you and your medical malpractice case. Is that true? Or is it just the opposite? You want to know the answer? Come join me for a walk along this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So to answer the question, is it beneficial for you during the course of your deposition in your medical malpractice case to go ahead and go on at length explaining to the defense attorney exactly every single detail of every single event that occurred in your particular matter? Is that true? Is that good for you? In my opinion, the answer is no, it's not. And you might be thinking, wait a second, that does not make intuitive sense. Isn't the goal of a deposition so that you have an opportunity to go ahead and tell your entire story? To tell the opposing lawyer every single detail of every single event that occurred? Let me share something with you that will disavow that notion once and for all. The answer is no. That is not the purpose of a deposition. A deposition is designed so that you can answer the defense lawyer's questions. That's it. If, for whatever reason, the defense lawyer does not ask you the appropriate questions necessary for him to get the information he needs, that's his problem. Your goal at a deposition where you answer questions under oath, and in pre-COVID times, that would typically take place in your lawyer's conference room, where the defense lawyer would be there, your attorney would be there, and a court stenographer would be there. During COVID times, this typically takes place now on a Zoom video call with the same people on the call. Now, you should know something important. Your answers represent your sworn testimony, and that's critically important. And that information can and will be used against you during your trial, because the defense will look for details on places where you have contradicted yourself, or places where the information you have provided differs from what's contained in a medical record, or differs from what another witness has said. So just keep in mind that the more you talk, the more opportunity you are giving to the defense attorney to find areas that are inconsistent or contradict other information in the record or from other witnesses. Now, you think and you get in your mind, you have this perception, this understanding, that this pretrial deposition session, which by the way lawyers also call an examination before trial, you think that it's critically important for the defense attorney to understand every minute little detail of every single thing that happened to you leading up to the event of the malpractice, as well as every little minute detail and interaction you had after the malpractice, all the way up until today when you are being questioned. The reality is, no, that is not the purpose. The purpose of a deposition is, number one, to lock you into your testimony, so that now when your case gets to trial a year or so down the road, you can no longer change your answers based upon the testimony and the answers that you gave. The point is, the number one purpose is to lock your testimony in so that you cannot change it at the time of trial. Number two, it gives the defense an opportunity to learn in your own words exactly what happened to you and what problems you have now because of whatever occurred to you. Another key important point of having a deposition is so that the defense attorney has a chance to see what type of witness you are going to make if your case goes all the way to trial. The attorney makes a judgment call about whether you're going to be a great witness, a poor witness, whether you're going to be likable or not, and that factors into evaluating your particular case. Now, what is the defense attorney going to think if you are asked a very specific, direct question about whether you had a conversation with a particular doctor in the hospital? And instead of answering the doctor directly, you choose to go on a long-winded explanation about conversations you had with many other people. What is the attorney going to think when you do that? In your mind, you may think, oh, he needs to know this information because, and now you justify in your own mind about why this information is so important or so critical, when in fact it's just the opposite. It tells this lawyer that you can't listen to instructions. It tells this lawyer that you are incapable, at least for this question, of answering a direct question. It tells this attorney that you are not paying attention and don't truly appreciate the reason for why he's asking you these questions. In that instance, now the attorney's perception of you as a potential witness has dramatically changed and likely will change. Why? Because you seem to think that the more information he didn't ask for, the better it is for you in your case, when in fact just the opposite is true. Now, Let's take that to the other extreme. Let's say the attorney asks you a very specific question and you answer with a one-word answer. Okay, now he's going to know that you are going to go ahead and answer only his direct question, which means he's going to be asking many, many more follow-up direct questions. And that's perfectly okay. So why do I bring this up? I bring this up because this happens so often in these medical malpractice cases, these accident cases, these wrongful death cases, where the injured patient, the injured client thinks that the more they talk, the better it will be for their case, the more impressed the defense attorney will be, and the quicker their deposition will finish, when in fact, just the opposite is true. You know, I realize you're likely watching this because you want to see the gorgeous scenery here. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.